are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5054, Cato Institute appellant versus Securities and Exchange Commission et al. Mr. McNamara for the appellant, Mr. Berger for the appellee.
Good morning, Mr. McNamara. We'll hear from you.
Thank you, Your Honor, and may it please the court, Robert McNamara for the Cato Institute. The judgment below should be reversed because the Cato Institute has standing. Cato has been injured. It wants to host events and publish books and articles featuring firsthand accounts from people who have previously been defendants in SEC enforcement actions. And it has identified people who would be willing to speak at these events and have their stories featured in these publications, but for the fact that all of them have entered into gag provisions that the SEC demanded as a condition of settling the initial enforcement action. That's an injury, and it's an injury that's traceable to the SEC because the amended complaint makes clear that the only reason these people are unwilling to participate in Cato's speech is that they fear the SEC.
Why is it just traceable to the SEC? Isn't it also traceable to each one of these individuals who entered into this contract or consent decree?
It's traceable to the individuals, Your Honor, but on the amended complaint, there's no question that if these individuals were not subject to these orders, if they could speak without fear of punishment, they would speak. And I think the best case to look at for that is this court's decision in the Woodhull Freedom Foundation case earlier this year, which made clear that the only thing that's necessary for traceability and redressability is a substantial likelihood that the plaintiff will be able to do the thing they want to do. In Woodhull, the plaintiff was a licensed masseuse whose complaint was that Craigslist had stopped hosting his ads after the passage of a federal statute regulating the internet. And Craigslist was not a party. The only thing he had were some press statements, I believe, that Craigslist had made, suggesting that if they could, they would go back to hosting ads like this. And that was enough. Here, the amended complaint alleges more.
The plaintiff in Woodhull couldn't get his ad posted, right?
Yes, Your Honor.
So, but here, what we have the restraint in front of us, and it's crystal clear that it binds the settling defendant, but it doesn't bind Cato. So what's to prevent, and Cato has this information, what's to prevent Cato from simply publishing it?
Two responses, Your Honor. First, as I understand it, Cato doesn't have the legal right to publish this without the permission of the speakers themselves. They have a conditional contract, as they understand it, to publish the book. But beyond the book, Cato wants to have events featuring these people actually talking, answering questions from a Cato expert. The amended complaint says that Cato has found that the most effective way to do this kind of advocacy is actually to put former defendants in front of the audience, have them talk, have them answer questions. And they are unwilling to do that solely because they fear they will be punished by the SEC if they participate in a panel discussion like that. And so Cato is unable to engage in the most effective speech that it has found in its consistent advocacy in this area. And that's an injury. And it's an injury that can be redressed if Cato can obtain a declaratory judgment that says the First Amendment does not allow the SEC to punish people for speaking at Cato's events. Not only does Woodhull stand for the proposition that an unregulated party can raise an objection like this, provided they're actually injured, Woodhull is part of a long line of this court's precedents holding exactly that, whether it's Teton Historic Aviation Foundation or Abigail Alliance for Better Access to Developmental Drugs, where there, the only evidence that the third party would actually give the plaintiff what they wanted if they prevailed was what this court called the naked capitalistic interest of the.
So if you prevailed, and I know this is, I'm talking a little bit about the merits, and I think and one of the problems I have here is separating the merits from the question of jurisdiction and standing. But if you prevailed, the redressability problem would amount to what? Nullification of the bar against criticizing or claiming that the SEC didn't have evidence? Is that what?
Not necessarily nullification, Your Honor. I think the only thing Cato would need for the narrowest redress of its injuries is a declaration, and obviously we'd have to put forth evidence to support the final judgment, but a declaration that says these people say these things at Cato's event. They cannot be punished by the government for saying.
Okay, well, that's what I suspected. But there are a lot of SEC consent decrees and a lot of defendants who have absolutely no connection to Cato's. Suppose they just wanted to go to a family gathering and tell people, would that, would whatever redressability problem you are talking about, would that mean that they could not be held to the consent decree either?
Not necessarily, Your Honor. And I think this question really goes to whether we'd be able to obtain facial relief or as applied relief. And I'm certainly prepared to argue for our right to obtain the broadest possible facial relief. But I think for standing purposes, it's enough to say that Cato could obtain the narrow declaration that would actually redress its injury and allow it to have, as for example, a panel discussion featuring these particular people.
So are you claiming that Cato has a First Amendment right here?
Yes, Your Honor. Cato is a First Amendment speaker, and I think the clearest place to see that in the court's precedents is the Supreme Court's discussion in Simon and Schuster, where it says it doesn't really matter for First Amendment purposes whether we think of the First Amendment speaker as an author who is subject to a regulation's burdens, or whether we think of the First Amendment speaker as the publisher who is limited to only publishing with authors who are willing to shoulder the burdens of that regulation. Cato here is the publisher, among other things. And I think Simon and Schuster teaches that the publisher is a speaker just as much as an author is a speaker.
But Simon's,
yeah, go ahead.
Simon and Schuster was not a standing case. I mean, the Supreme Court was not purporting to make any sort of a holding on standing. And we know from Steele Co. that we're not supposed to rely upon drive-by jurisdictional rulings or holdings. So, I mean, isn't this really more akin to a third-party standing case here where you're saying, we have a right to hear information from another speaker, and that speaker is impeded from speaking to us and participating in our forums and allowing us to publish their books? Isn't this really more akin to that line of cases where you are really, in effect, standing in the shoes of a third party asserting their rights?
I don't think so, Your Honor. And we don't rely on Simon and Schuster for the jurisdictional point so much as for the point that as a publisher, Cato is just as much a First Amendment speaker as the author is. I think that answers that part of the question. But Cato doesn't just want to receive information. It's not just raising the rights of third parties. The amended complaint specifically alleges in paragraph 45 that Cato has found that the most effective way to convey its own message is to be able to present these sort of testimonials from defendants, from people who've participated in the criminal justice system. And it wants to engage in that speech, not just to hear it for itself, but to broadcast it, to host events, to speak in its own right, telling these stories.
Well, one of the cases that you cite in support is the Pitt News cases from the Third Circuit. And
Yes,
what the Pitt News does and what we have done in cases like American Library Association v. Odom, which is not a case that either party cited, but those cases say you have to also look at prudential standing because you're having someone in effect standing in the shoes of the real party and interest, so to speak. And so you have to look at things like whether that other person is really hindered in bringing their own suit. And I don't see any allegations in your complaint that say that. And also you have to ensure that there's a complete alignment of interests of the plaintiff with this other absent party. And that also concerns me because you say in your reply brief that you can prevail even if the settlement agreements get blown up, so to speak, and invalidated, you'll still get relief. But if that happens, if that were to be the result of this lawsuit, these third parties will be worse off than they are now, and so your interests aren't aligned. So why shouldn't I be concerned that granting standing for you is not consistent with the Pitt News line of precedent or the third party standing precedent in the Supreme Court in our court?
So two responses, Your Honor. One, I think the question of whether a ruling in our favor would blow up all of these settlement agreements across the board, again, goes to the question of whether we could receive a facial or an as-applied remedy when we get to the merits. I continue to disagree that under the Kuntz case, the result of any First Amendment ruling would be to blow up these agreements as opposed to just restraining the SEC from enforcing its unconstitutional condition. But I also disagree, Your Honor, that the Pitt News cases are solely third-party standing cases. In Pitt News, the Third Circuit said the newspapers didn't have third-party standing, that the alcohol retailers could perfectly well have litigated under their own rights. But because the newspaper was a publisher that wanted to publish these advertisements, it had standing in its own right. And I think Cato's in exactly the same position. In Pitt News, there was no evidence in the record that I saw in the opinion that the regulation had even been enforced against these retailers. The retailers, out of an abundance of caution, were complying with the regulation. As a result of complying with the regulation, the newspapers could no longer run their ads.
But I guess to me, the bigger point with Pitt News is that the court did feel that it was duty bound to undertake the prudential standing analysis. And if we also believe that we are duty bound to undertake that analysis, and what we said in Odom was that if the plaintiff may have a conflict of interest with the absent party, we held, and that was a basis for the holding, that there was no standing.
Oh, again, two responses, Your Honor. One, I'm not sure the extent to which prudential standing continues to be operative after the Supreme Court's Lexmark decision. But again, I don't think there is a conflict of interest.
Also, it's Patchak decision too.
Yes, Your Honor.
Yeah.
But setting aside prudential standing, which I don't understand the SEC to have raised, I don't know that there is a conflict, at least as to the people who have specifically told the Cato Institute that they want to speak at its events. And again, I just think this goes to the question of whether we'd be entitled to a facial remedy as to all of these agreements, or an as-applied remedy as to Cato's events and the people who want to speak at Cato's events. And just
why does that solve Judge Wilkins' problem, even if there's a narrow, targeted, as-applied remedy? Cato is helped only if there is some speaker who comes to Cato's events and publicizes the alleged SEC overreach. And when that happens, as to that defendant, the SEC would seem to be well within its rights to go back to the court and say, this defendant has breached our agreement and we now want to proceed with enforcement.
Well, I think that's where the declaratory judgment would come into play, Your Honor. That I don't understand the SEC's position to be that if we obtain a declaratory judgment in this case, they will nonetheless punish people for speaking at Cato's events. I understand their position to be that if they're unable to enforce these, they will assert a broader right to reopen, for whatever reason, any settlement agreement that they want to. Not that they could say, this person has said bad things about our prosecution, and therefore, despite the declaratory judgment that says it would violate the First Amendment for punishing them for speaking at Cato's event, they can still be punished for speaking at Cato's event.
What seems to me lost in this whole discussion, including in the briefs, is the fact that we're not dealing with an agreement simply an agreement between the SEC and a private individual. This is a consent decree is a judgment that a court enters. And there's a rule that says when a court enters a judgment and you violate it, you're in contempt of court. And it seems to me that that a looming question here is how do you, how can one court order another court's decree to not be followed? Wouldn't you have to go back to the judge of the district court that issued the consent decree and get them to modify it? Isn't that the only way that that can be changed?
No, Your Honor, and I just want to be clear at the outset that this is actually a factual dispute between the parties that hasn't been resolved. The SEC contends, and I see I'm over my time, the SEC contends that all of these gag provisions have been incorporated into consent judgments. They've been incorporated by reference. That is not correct. And we collect a number of examples in our opening brief at footnote 2. So there are at minimum a large number of these that are not actually part of a consent decree. They're just an agreement the SEC has entered into that has not been incorporated into the final judgment of any court.
But there is one that's attached from the District of New Jersey in which it's at JA 59, in which it is incorporated into the judgment. And so, or at least there's, I guess there's a consent, I guess it's a consent document. I'm not sure exactly how to characterize it. That's filed. But I think to Judge Randolph's point, isn't there at least a possibility that our declaration is going to conflict with an order that has been entered by another court that's not even in our circuit?
I don't think so, Your Honor, and that's because final relief in this action would have to be entered based upon a record. And I don't think even the judgments that incorporate the consent order amount to a continuing judgment of another court. But even if I'm wrong about that, we've established that there are a number of these that are not incorporated in any kind of consent decree actually entered by an Article 3 judge. And our relief could simply be limited to saying that to the extent that matters, the relief is limited to these people that the plaintiff has identified whose gag provision is not incorporated.
Well, if it's not incorporated, then the only what's the consequence of the individual not following it? It's just a breach of contract, and the SEC is entitled to what, damages?
I believe the SEC would take the position that even if they have not been formally incorporated, that they're still going to retain their full panoply of rights to defend them. The SEC could certainly say that that's not the case and they don't have the right to enforce them, but I don't understand the SEC to have ever taken a position that they have fewer rights to punish people for their speech, depending on whether it's been formally incorporated into a judgment.
There's no judgment. First, make no law restricting freedom of speech. What is a contract? Can a contract be a law restricting freedom of speech for First Amendment purposes? The party has a right to speak and contracts it away. That doesn't seem like a First Amendment violation.
Again, Your Honor, I think we're racing ahead to the merits, but I do think it can be if the executive is using the full panoply of its powers to coerce people into surrendering their First Amendment rights. And the case to look at here is really the Fourth Circuit's decision from last year in the Overby case, which is on all fours with this case. It was a challenge to a very similar City of Baltimore policy of demanding gag orders as a condition of settlement. And really the only difference is here we have substantial allegations that specific people would speak at our events and be quoted in our publications. In Overby, the Fourth Circuit found standing based on a single allegation that was one sentence long about the difficulty of, about the fact that the policy impeded the newspaper's ability to carry out the important role the press plays. We have more here than Overby did. Overby recognized that demanding settlements like this, that demanding gag orders like this can violate the First Amendment, and that third-party newspapers have standing to seek forward-looking relief to challenge them.
But in Overby, you also had the person who had signed the settlement agreement as a co-plaintiff. And the court clearly had jurisdiction over the Baltimore Police Department as the District of Maryland and the Fourth Circuit. So you didn't have a problem where the speaker who was directly regulated wasn't before the court. There wasn't a potential for conflict of interest, and there wasn't a potential for getting crosswise with another court's order.
Respectfully, Your Honor, I disagree. There was a person in that case who was subject to one of these orders, but in considering the Baltimore Blues standing for forward-looking declaratory relief, as to other people, the Fourth Circuit had to specifically find it had standing to seek that forward-looking relief, and it was very specific that that forward-looking relief was based on this one-sentence allegation, and it was the right to challenge these orders more broadly than just the one plaintiff who was before them.
All right, any other questions from the panel?
Nope.
No.
All right, thank you, Mr. McNamara. We'll give you some time on rebuttal. We'll hear from Mr. Berger.
Good morning, and may it please the court. Jeff Berger for the Securities and Exchange Commission. The district court correctly ruled that the Cato Institute lacks Article 3 standing to launch a broad programmatic challenge to the commission's use of contractual no-deny provisions in consent judgments. And to be clear, Cato Institute, the plaintiff, has not entered into a consent judgment with the commission that binds it or creates any legal consequences for its speech. There is no legal obstacle to Cato publishing a book or hosting seminars or hosting conferences. Rather, to Judge Wilkins' point, this is a third-party standing case because Cato premises standing on a derivative injury, namely that unnamed defendants who previously entered into consent judgments and who are not before the court are declining to speak. This theory of standing fails because it is based on the subjective chill of non-parties who have not even been identified. So Cato's challenge to the way the commission settles cases, there's no legally cognizable injury that's concrete, particularized, and actual or imminent. And under this court's and the Supreme Court's precedent in cases like United Presbyterian, in Laird, and American Library Association, and I'm referring to American Library Association v. Barr, not the case Judge Wilkins was referring to. Cato is stating, and I have emphasis on what it states in its reply, it says that Cato's injury is that people are refusing to speak because the commission could move to vacate the consent judgments, emphasis on could move, if there's a public denial of allegations. There is no other consequence that could result from a breach under these contracts.
Are you saying there's no reasonable likelihood that if settling defendants start broadcasting their stories to the world, that the commission won't exercise its right to continue with enforcement against them?
I think it depends on a large number of facts and circumstances, and we, both us and the SEC and this court, have been deprived of any information regarding those facts and circumstances. Let me walk through some of them. One is, what is the nature of the case? Two is a very practical matter, and something that really is something that could drive the train, is how old is the case? What court entered the case? What were the remedies in the case?
We don't know for certain. There's no doubt, but usually we assume people will, or governments will, enforce laws, or in this case, consent decrees, right? It's the unusual case, the Poe versus Ullman kind of case, where there's a law on the books, but the possibility of enforcement is shown to be very remote, and that has consequences for standing or ripeness purposes. No reason to think that the SEC is insisting on these provisions in its settlement contracts, just with indifference to whether defendants broadcast.
It's not with indifference, but it is with a recognition of reality that depends on circumstances. For instance, a case where a defendant publicly denies the allegation 6 weeks after the settlement is entered is going to be a different calculus for the commission about relitigating the case, or I should say attempting to relitigate the case, than something that happens 16 years later. the commission has to make a decision if there's a public denial. Does it want to dedicate its current resources to relitigating a past case? Does it think, for instance, that the evidence is still attainable, memories are still there? Are the attorneys who litigated the case, do they still even work at the commission? As well as the fact is, what is a district court going to respond to a commission attempt to reopen or relitigate an old case? And my point here is not that this won't occur, is that we don't know anything about these particular cases. And this gets to the problem with the subjective chill nature of this case. It's one thing if the plaintiff who is bringing the case has a subjective chill issue. That's where cases like Laird and United Presbyterian say that there's no standing. But here it's even more complicated. It's even more complicated because we haven't been given any information about the unnamed defendants who are not the plaintiffs.
I don't understand what you mean by subjective chill. If an individual is under a consent decree or has signed a contract, a settlement contract, there's nothing subjective about that. If there's a clause in there that says you can't criticize the SEC, what's subjective about that?
I mean, I think it's subjective because it's a refusal to speak based upon a guess or a view about what could occur in the future in terms of whether the commission would actually seek its contractual remedies, as well as whether a court would grant it.
But that's talking about what the commission's going to do, not what the individual's reaction to a clause restraining them from talking.
I'm sorry, Your Honor, I didn't mean to cut you off.
Yeah, go ahead.
No, I mean, and this gets to the question that is at the core of cases like Laird and United Presbyterian is there immediate threat of concrete action? And this gets to the problem with the allegations in the complaint. There is no allegation of an immediate threat of concrete action with regard to these particular defendants that Cato is saying are refusing to speak to it. All you have, and Cato, particularly in its reply brief, places an enormous amount of emphasis on a single allegation. It's at JA 12, it's paragraph 30. And all they say is upon information and belief, and let's just assume the court accepts an information and belief allegation of this sort, is that the commission has demanded that other former defendants with whom Cato has no relationship, that the commission has issued retractions. Now, I'm not quite sure what issue retractions mean, but that is a far step from the commission having taken any concrete, immediate, present action with regard to the particular unnamed defendants that Cato has.
Yeah, but it is a fundamental part of free speech law that if an individual is subjected to a law, in this case, a consent decree that restrains their speech, they don't have to violate it first before they can challenge it. And that's unlike other areas of the law, but with respect to First Amendment free speech, that is a standard boiler or a standard, black letter rule that you don't have to violate it before you can challenge it. So why should Cato be under any kind of different constraint?
Because I think this has everything to do with the difference between a statute and a contractual remedy. I absolutely accept your point, Judge Randolph, about a statute. And if this was simply you cannot say X, I agree that in cases there's a presumption that if there is a violation of X, if you've said X, that the agency charged with the authority to enforce is going to bring in enforcement action. You can assume that. But here in a contractual provision where the commission may not exercise its rights and a court has to basically approve it to bring a case back, it's a different circumstance. And I do think this brings up both the prudential consideration.
On the specific question of likelihood of enforcement, why does it matter that the obligation arises by contract rather than by statute?
I think it makes a huge difference in terms of whether the commission, in terms of what Cato has alleged the commission has done, whether the commission will actually seek the remedy, particularly when we don't know anything. Again, the court is being given a broad programmatic challenge without any facts with regard to a particular consent judgment. That there are circumstances where the commission may simply let the speech go and may not do anything. I think when a statute says you can't do X, the commission does not have that liberty to sort of say, well, we're just not going to enforce the law. And I grant you prosecutorial discretion, I grant all that. But it is still different that there are circumstances where the commission may simply decide it is not worth either its time or the court's time to attempt to relitigate a very old case. But I do think the prudential considerations that Judge Wilkins raised, as well as the sort of comedy invasion of another court's jurisdiction issue, that does factor in here. And it factors in the following way, which is if the commission does decide, meaning if these unnamed defendants were to speak, and the commission were to actually determine that it wants to seek its contractual remedies, one is the commission, again, would have to bring a motion pursuant to the terms of the consent judgments. It would be, at that time, the plaintiffs, the individuals who signed the consent judgments, I don't mean to say plaintiffs, the unnamed defendants who signed the consent judgments would have an opportunity before that court to make any arguments they want, including the types of First Amendment arguments you'd have here. That would be in a more specific way. The issues would be more clearly presented. But also, it's not asking this court, which is what Cato is doing, is to basically invade the jurisdiction of every single court that has entered a consent judgment. And I do think it's important to talk about the fundamental mismatch between what Cato is asking for here and the injury it claims. So Cato, for instance, is asking for an injunction against all future no-deny provisions, but it's not claiming an injury related to future consent judgments or future no-deny provisions, nor does it claim any injury from past consent judgments signed by other defendants who may not actually wish to deny. They may not wish to have their settlements changed. They like their settlements. They like to keep it in the rearview mirror.
As to the prudential arguments you're making, that really what's going on here is we have a plaintiff asserting the rights of third parties.
Yes.
That may be a good argument, but it's a prudential standing argument, and pretty clear after June Medical that prudential standing arguments are forfeitable. And you've argued this issue solely in Article 3 terms.
I disagree with that, Your Honor. On our motion to dismiss, we certainly raised prudential arguments. We talked about it not only in terms we're talking about now, in terms of the ability of the unnamed defendants to have a day in court, but also in terms...
You didn't, not in the red brief.
No, we did talk about prudential standing in the red brief as well. In particular, we talked about in terms of on page 19 of our brief, we talked about the skepticism courts have in a prudential jurisdiction context about allowing plaintiffs to advance claims based on contracts to which they're not parties or intended beneficiaries. Okay. The prudential standing issue also, comes into play as part of the sort of comedy analysis that comes, more and granted in terms of our ripeness argument. I mean, I do take your point. Look, prudential standing has obviously changed in the past few years.
Is prudential standing constitutional?
No, it is not. In my view, I don't view
what I meant by that is that where does the Supreme Court get the authority to deny jurisdiction over a matter that Congress said is within the jurisdiction of the federal courts? Is that constitutional for the Supreme Court to do that?
That's
what's driving these cases. The Indian casino case that I mentioned is a perfect example of that.
Look, it's a great question. It's an interesting question. Ultimately, I think this court can decide this case on Article 3 grounds without dealing with that difficult question, which probably goes back to what the Supreme Court's authority is.
Let me ask you a broader question here,
sure,
because we're arguing back and forth. And I said earlier that it's hard to separate the merits out from the question of standing. But is this case really analogous to something like Bell v. Hood, where the Supreme Court held that you don't throw a case out on jurisdictional grounds simply because it appears that the individual will not be able to recover? And Bell v. Hood was 20 years before Bivens. The claim was that you can get damages under the Fourth Amendment, and the court threw it out on jurisdictional grounds. Isn't that really what we have here? I mean, Cato has an injury, it claims redressability, and it claims causation.
Sorry, Judge.
Yeah, go ahead.
No, we sharply disagree with all three of those. Cato doesn't have an injury here. Cato has a derivative injury that's based on basically the chill of third parties about whom we know nothing, without any allegations of where there would be a claim of specific present objective harm other than the chill, or any specific action that's threatened or even contemplated against them. Obviously, nothing can be threatened or contemplated against them. We don't even know who the people are. And that's Cato's litigation tactic that they chose. which is to bring a broad programmatic challenge without giving the court the ability to ferret out what's really going on in the sense of what are the consent judgments? When were they?
Well, if that's your problem, you can have jurisdictional discovery.
I mean, that is one of several problems that we don't know the identity of the people, which is required by cases like Friends of Earth and Summers. But even if that were to be provided, you still have the problem that there's absolutely no allegation in the complaint, which we take as it is, that the commission has contemplated or threatened any action. And that is what the Supreme Court requires in Laird. But if we're talking about the sort of, fundamental sort of take a step back issues, I mean, I think the Supreme Court has also been real wary of accepting programmatic level challenges where the injury is not direct to the plaintiff, which is what we have here, because Cato is not subject to a consent judgment, but instead is advocating the views of, in essence, someone else without having done their work. I'm almost out of time. I did want to talk about Woodhull and Pitt News, but.
Well, let's assume we disagree with you on the reasonable likelihood of enforcement as against the one speaker they have. I thought, so then you make a different argument, which is that the only restraint at issue runs against the third-party defendant who's not before us, and Cato is free to publish. So I was wondering about that. I mean, isn't a fair reading of the complaint that Cato is bound not to publish because the third party can't speak? They're not really clear about this, but it seems like a reasonable reading of the complaint is that the third parties are going to Cato and saying, here's information, you can know about it, you take legal advice about whether this is a lawful restraint, but we are not authorizing you to publish it to the world.
I mean, it's an interesting facet of the complaint, right? Which is that Cato only, according to their own allegations, enters.
Sorry, just your response to that is to say that Cato faces no exposure vis-a-vis the commission, which is clearly true, but they might face exposure vis-a-vis the third party if the third party has told Cato, we're giving you this information, but we're not authorizing you to publish it.
I mean, if the argument that Cato's injury is that their contract with the author could somehow be disrupted, I mean, they entered into that contract, according to their own allegations, knowing full well about the no deny provision. But if this is more asking a question sort of about the Overbay case and the idea of sort of the ability to receive information, I mean, Cato is fully obviously alleged that they were able to receive the information, and that distinguishes Cato from the newspaper or the magazine that was involved in Overbay, where the whole allegation.
It's the ability to publish information.
That's not how the Fourth Circuit articulated the injury, and that's not how the Baltimore Brew articulated the injury. It was the ability to.
Why isn't that the right way of thinking about it? They have information, they want to publish it, and they can't because of the restraint you all have imposed on the third party who gave them the information.
I mean, but if you think about it then again, it moves the injury from Cato's injury back to the derivative injury of the third parties. And we're back to the whole line of Chill cases and Laird and United Presbyterian, and moves away from what the issue was in Overbay.
I mean, I guess I'm just trying to figure out if you have a level of defense besides number one, third party standing, and number two, unlikelihood of enforcement of the SEC enforcing against the third party, or are those your two?
No. I mean, I think there's issues with actual or imminence, but then those also bleed over into traceability and redressability. Traceability is because of the large number of events that have to occur, and part of redressability is, let's just talk hypothetically, if the court were to grant the broad relief that's being sought here, in essence, line iteming the consent judgments of the individual unnamed defendants, The commission may not want those settlements anymore. It may seek to vacate them, which leaves those unnamed defendants in the exact same position, which is that the commission has the option, not the obligation, but the option to ask a court to undo what has come before. An option that a court may very well say, nope, sorry, you're out of luck, commission. We're not going to let you relitigate the case. I'm well over my time, so.
All right, are there further questions from the panel?
No.
All right, Mr. McNamara, you were out of time. We'll give you 2 minutes for rebuttal. I have a question that I forgot to ask during your opening, so let me begin by just asking that. What are the limits to the principle you want to establish here? So suppose Cato or some other entity were interested in waste, fraud, and abuse in the government, whether it's the courts, Congress, executive branch, and they say, we'd like to hear from, law clerks, congressional aides, government officials about waste, fraud, and abuse, but there are all these rules and regulations that prevent them from speaking to us, and they could get fired, or there could be, there could be ramifications. So, we want to be able to challenge each and every one of those regulations as because it's impeding our First Amendment rights to kind of be able to effectively advocate against waste, fraud, and abuse, et cetera. My problem is that if we accept standing for Cato here, don't we just open the floodgates for anyone who wants to publish speech of someone affected by a government regulation to be able to indirectly challenge each and every regulation like that?
I think we'd have two problems bringing that lawsuit, Your Honor. One, a factual problem. We'd have to be able to identify the particular speaker who has written a book and come to us and said, you can publish this book full of confidential information, which is going to be a difficult factual thing to find, because at that point, the law clerk or other government employee has already breached his duty. And so I don't think we'd be able to find and plead that we had the actual speaker. And we'd have a merits problem, where I think there's a very different First Amendment calculus between the government saying, in exchange for us giving you access to this confidential information, you have to promise not to disclose the confidential information, and saying, in exchange for us letting you plead to count one, you have to promise never to question the accuracy of count two. I just think that the First Amendment calculus would be different. But the standing problem I see there would be a factual problem much more than it would be a legal problem. I can't imagine a plaintiff having the sort of concrete speakers that we have here. And if I could make just 2 quick points on rebuttal, I think this is not a subjective chill case. The subjective chill cases like Laird and American Library Association v. Barr all involve plaintiffs who it wasn't clear they were even going to engage in activity that would be illegal under the law. Here, we have people who have specific agreements that say they specifically may not say these specific things. And the only way to say them is to risk expensive litigation, which I think the Supreme Court and SBA list made clear. We can't expect people to choose between engaging in protected speech and retaining attorneys for potentially extremely expensive litigation. And second, Your Honor, my friend complained several times that the record before us doesn't identify each speaker. And I just want to stress again that this is a remedy problem. We're up here on the pleadings. And of course, before a court enters a declaratory judgment, it will have a full record before it of who has contacted Cato and exactly what they're willing to say. And at that point, I think we can wrestle with any of these problems. And I'm happy to do that there. I don't think it's a 12B ground for dismissal. Thank you.
All right, thank you. We have your argument, and we'll take the case under submission.
Case number 20-5002, Jason Leopold and BuzzFeed Inc. versus Central Intelligence Agency appellants. Mr. Busa for the appellant, Mr. Light for the appellee.
Good morning, and may it please the court, Joe Busa on behalf of the government. Plaintiffs don't dispute that the information at issue in this FOIA case is classified, that it relates to CIA sources and methods, that its disclosure would damage the national security, and that it therefore falls within the protections of FOIA exemptions 1 and 3. The government could be compelled to release this protected information only if it had unambiguously already done so in a prior official acknowledgement. Because the government has never acknowledged the specific information at issue here, it remains protected, and the district court's disclosure order should be reversed. Plaintiffs have the burden of identifying specific prior statements that they say acknowledge and constitute an official acknowledgement. Here, they identify a single 20-word tweet sent late at night, whose core message is that an unspecified newspaper article, quote, fabricated the facts, end quote, in an unspecified way. This is miles away from the kind of official acknowledgement this court would require to overcome the government's Glomar response here. That is so for 2 reasons. First, the tweet doesn't say that there were payments to Syrian rebels that the president knew about and ended. Second, even assuming that the tweet did say something like that, it certainly says nothing whatsoever about the CIA and whether the CIA has an intelligence interest in that subject or doesn't, or whether the CIA has the intelligence gathering capability to learn about such alleged payments by unknown entities to Syrian rebels.
What about the statement the following day in the interview to the Wall Street Journal that says, that was not something I was involved in other than they came and they suggested, it turns out it's a lot of Al-Qaeda we're giving these weapons to?
I have 3 things to say about that, Your Honor. First is that plaintiffs have affirmatively waived any argument that the interview is an official acknowledgement of anything. Here I'm quoting from plaintiffs' submissions to the district court, that's docket 11, page 1, footnote 1, where plaintiffs say, the only question the court needs to address is the impact of the tweet on what would otherwise have been a valid Glomar response. And so plaintiffs should not now be taken to raise an entirely new argument on appeal that they affirmatively conceded away in district court. The district court took them at their word and in fact only analyzed the tweet. And it's too late to raise a new argument. But even if the interview were to come in, Your Honor, I have 2 substantive responses. First, just like the tweet, the interview says nothing, not one word about the CIA, its intelligence interests or lack thereof in this arena, or its intelligence gathering capability or lack thereof in this arena. That's the specific protected information at issue, and the interview says nothing about it one way or the other. And also, secondly, my second substantive point on that is that the tweet actually doesn't even say anything about acknowledging payments to Syrian rebels. Those words appear in the tweet as the subject of the FOIA request here, and the interview doesn't say anything about that issue. In fact, it's even more ambiguous than the tweet. It talks about a decision.
But it says a lot of Al-Qaeda we're giving these weapons to.
Your Honor, there's no...
Assuming just for the sake of argument that we can consider it, I take your point that this may be waived, but if we can consider it, isn't that an acknowledgement that the U.S. has given weapons to Al-Qaeda? And isn't it basically common knowledge that the CIA has an intelligence interest in Al-Qaeda?
Your Honor, there is no basis to assume or speculate that the CIA would have any intelligence interest or knowledge about an alleged program of payments to Syrian rebels. If that were the law, the ACLU opinion would have read very differently. In ACLU, it was undisputed that the US government used drones in targeted killings. The question was whether the CIA had an intelligence interest in that subject, and the opinion would have been very short if it had just rested on the grounds you just outlined there. Instead, consistent with this court's longstanding specific match test, the court there looked to the CIA director's statements acknowledging an intelligence interest in the use of
what are we to
There's
do
nothing.
what are we to do with the language on the ACLU v. CIA opinion from 2013 that appears at the beginning of page 430 of 710 F3rd? The paragraph that says, given these official acknowledgments that the U.S. has participated in drone strikes, it is neither logical nor plausible for the CIA to maintain that it would reveal anything not already in the public domain to say that the agency at least has an intelligence interest in such strikes. The court reaches that conclusion before even getting to, the pages and pages more that it says about the CIA director statements, et cetera, et cetera. It seems to be holding there that before we even take any of that into account, it's not logical or plausible for the CIA to say that they don't have an intelligence interest in drone strikes.
Your Honor, we think ACLU is best read as being consistent with prior precedent that bound the panel, outlining the specific match test. This court has long made clear for about 40 years now that in order to overcome an official acknowledgement, plaintiffs have to identify prior statements that are as specific as and match the specific protected information. This court said in Wolf that this court insists on exactitude in order to protect important national security interests, and that speculation, no matter how widespread, is no basis for finding an official acknowledgement, because anything less than that exacting standard would provide insufficient protection for CIA sources and methods. As this court said in Gardell's, an official acknowledgement ends all doubt. That's why what this court said in ACLU is true, that this court demands a prior statement that, quote, leaves no doubt, end quote, about the content of the protected information. Now, taking all of that into account, we just don't think that that paragraph that you were reading from is the holding of the case. The case ultimately rested on the specific statements from the CIA director. And that's consistent with the prior precedent. And that's also how this court has read ACLU after ACLU was issued. We cite at page 41 of our opening brief a case in which this court characterized ACLU as ultimately resting on those specific statements from the CIA director. And, and a panel would just not have the ability to change the pre-existing specific match test. And so we have... I'm sorry, Your Honor.
Suppose we disagree with you regarding the first of the two inferences. In other words, we think there's acknowledgement that the United States government at some point was supporting Syrian rebels. And then you say, but there's a second inference, and a second protected fact, which is whether or not the CIA was involved in that. If we just looked at all of the federal statutes creating all of the intelligence and military entities of the government, would we find that there are agencies besides the CIA that could have been involved in doing this, in supporting Syrian rebels?
I have two responses, Your Honor. The first is that there's no basis to assume that this would have been a United States government program, even if you take the tweet or the interview or the combination thereof as acknowledging the president's knowledge about some payments to Syrian rebels. That's the basis on which this case was litigated in district court. The district court made clear that at most, the tweet could be thought to be official acknowledgement of the president's knowledge of payments. But the district court acknowledged, and so do plaintiffs, that even taking into account the tweet and the interview, such alleged payments could have come from anyone, including foreign entities, which is why it's very important to understand.
So sorry, just let me make sure I get this. So you would say one plausible reading of the tweet, President talks about president's word, my ending massive, dangerous, wasteful payments to rebels could mean that some foreign government was supporting Syrian rebels. The president didn't like it, and he cajoled the foreign government to end payments.
That's exactly right. That's what the district court said here. In fact, I don't even believe it was limited to foreign governments. I mean, any other foreign entity or any non-U.S. government entity could be at play there. And so that's one answer to Your Honor's question, which is that we're really not just dealing with the U.S. intelligence community.
So
the second answer...
So hang on. So just to play that out, let's assume, again, for the sake of argument, that we consider the statement to the Wall Street Journal. Then what do we do with the statement? Turns out we're giving weapons to Al-Qaeda. What's the plausible reading of that would not reference some United States government entity?
It's the same as the my ending phrase from the tweet, which is just that, the use of the first person in the one instance, or, the we in the second instance could encompass a broader coalition, or, the president working in conjunction with some other entity using his influence.
The we could be some secret coalition.
Hypothetically, yes, Your Honor.
Yeah.
And the key issue here is that an official acknowledgement ends all doubt. That's why there has to be an unambiguous official acknowledgement. And we just don't have that here, even on the first prong of what we're talking about here, much less about the CIA's interest or involvement one way or the other.
So assume I get that argument. Let's assume we disagree with you on that point. And then what's your answer? We assume there's acknowledgement as to some U.S. entity. What's your answer to my question about, just purely hypothetically, looking at the face of the statutes, is there some other U.S. entity that could have been doing this?
Hypothetically, one, I think the answer is going to be yes, but I don't think it's on us to identify a specific other agency that could have done the alleged payments at issue here. The intelligence community comprises 17 entities. They all have different legal authorities, and it is not a matter of indifference to the U.S. government and its national security, whether or not the CIA is publicly acknowledged to be involved in any even acknowledged U.S. government activity. That's because of the differences in the illegal authorities available to the CIA versus other potential actors. Whether those authorities are invoked could itself disclose other properly protected national security information. And just to be very specific here, the tweet says nothing at all about the CIA and its intelligence interests or lack thereof, its capacity or lack thereof regarding the subject here. That's the specific information at issue, and the specific match test is therefore not satisfied.
Is it really a burden? Is this really a burden of production question? I mean, they say there's official acknowledgement as to the United States, and the only reasonable way to read that is to loop in the CIA. And my reaction to that is, well, that just tees up a legal question about whether any other military or intelligence entity could have been involved other than the CIA. In other words, the plausibility inquiry that ACLU arguably mandates turns on a legal question of which agencies have which authorities.
No, Your Honor, I don't think the government is required to give up protected information in order to protect other protected information.
I mean, I'm not asking you about which agency was involved. I'm just asking you about, is there any other agency that could have been that would have had statutory authority potentially to be involved?
I don't know, Your Honor, and I don't think I'm in a position to give you a specific answer on that subject. The key here, though, is that the government has never officially acknowledged that there even were payments, much less that the U.S. government would have been the one involved, much instead of somebody else. And finally, and most importantly, none of these statements say anything about CIA involvement. If the rule were that official acknowledgement of a program is enough to make the CIA either confirm or deny its involvement or point the finger at somebody else instead, ACLU would have been a very different opinion. ACLU does not read that way. Instead, it reads consistent with this court's 40 years of precedent on this subject. It relies on the specific statements of the CIA director. There's no analog of those statements here. Plaintiffs don't say otherwise. Instead, the district court's disclosure order here relies on nothing more than speculation. The district court's assumptions about the CIA's interests and capabilities in this arena, but this court has made clear that speculation, no matter how widespread, cannot be the basis for an official acknowledgement because of the important underlying interests in national security.
Let me ask one broad question. Do you find, is there any difference between the New York Times versus CIA case and the Second Circuit in this case?
I don't see any material difference between those two cases, Your Honor, and I think that's another reason going in our favor. The panel there took a look at the exact statements that plaintiffs here point to as being alleged official acknowledgments, and the panel in the Second Circuit correctly concluded that, look, the tweet doesn't say that there were payments and the president ended them. Instead, the core message is criticism of the underlying article. And as we point out in our reply brief, if Alice says that Bob destroyed a car, and Bob says that Alice lied about my destroying a car, that does not mean that Bob is saying there was a car, right? The only necessary inference from the gerund and the possessive in front of the gerund, my destroying, is a reference to the allegation, not a confirmation of it.
It might be a little different if Bob says Alice lied about my destroying a red, shiny, beautiful new Cadillac.
Well, as we point out in our reply brief, the characterization here of massive, dangerous, and wasteful can be understood as the president's editorial gloss on the descriptions in the underlying article. We cite specific portions of the underlying article that could be thought of in that way. And that's exactly how the Second Circuit, getting back to Judge Randolph's question, thought about this question. The Second Circuit understood that, that is at least a plausible understanding of this tweet, and therefore the tweet does not constitute an official acknowledgement. And this court should reach the same conclusion for the same reasons.
All right, are there any other questions?
Not by me.
All right, we'll hear from you on rebuttal.
Thank you.
Mr. Light.
Good morning, Your Honor. May it please the court, Jeffrey Light on behalf of appellees Jason Leopold and BuzzFeed. The Glomar doctrine is a judicial gloss on the statutory text of FOIA. It's a legal fiction which allows an agency to refuse to confirm or deny the existence of records, even when it's obvious to the whole world that the agency maintains such records. In this case, after the Washington Post story revealed that the CIA program to the world, the government was still entitled to its fig leaf because of the need for the official government position to be one of plausible deniability. However, this need ended once the president himself, in his official capacity, removed that fig leaf. The precise Glomar fact that the CIA wants to maintain plausible deniability about is set forth on page 12 of their reply brief, which refers to Joint Appendix 18, in which they say that the Glomar fact is that revelation would show that the agency had involvement in, knowledge of, interest in, and or a connection to such programs. But the wording of the actual FOIA request is far broader than that. It's a 9-part FOIA request that specifically duplicates the language in President Trump's tweet, specifically any and all records mentioning or referring to, quote, the ending of payments to Syrian rebels fighting Assad. This is far different than what happened in the Second Circuit case, where the FOIA request was specifically about a CIA program. And that makes that case similar to the prior Leopold case, which was aimed at a CIA program in particular, and we lost that case. But the district court recognized here that the 9-part FOIA request here was much different. The CIA
has the New York Times case. Has the New York Times petitioned for certiorari or rehearing in bank?
No, that case is final.
Yeah, the time has run out, right?
I believe so. As far as the breadth of the FOIA request in our case, the government finds that problematic because they argue that it leaves room for speculation if they were to acknowledge the existence of records about which particular aspect of the FOIA request they're responding to. But that's the whole point of the Glomar doctrine, is to give the government enough leeway to leave enough doubt for them to have plausible deniability. The broader the FOIA request, the more room they have to say, yes, we acknowledged that there are documents that exist with respect to one of these 9 parts, but we can deny a specific fact, the specific Glomar fact that they want to assert here. In response to Judge Katsas's questioning about whether there were other agencies that might have had authority to have engaged in this, I'm not sure that there are any. I can't speak definitively to that. But assuming hypothetically that there was, the question is then, would it be obvious that the CIA has an interest in a sister agency conducting that? And I think that it would be implausible for the CIA to say, we didn't know, or we have no interest whatsoever in the Department of Defense doing this type of operation. It does not, acknowledgement would not.
How do we know that? I mean, intelligence community is known for sometimes being more siloed than it should be. And not every agency always knows what every other spy agency is doing.
Well, I think what's important here is the temporal scope of this FOIA request. Keep in mind that this FOIA request was made after the New York Times story, after the president spoke to the Wall Street Journal, and after his tweet. So the CIA would have to maintain plausible deniability that it had no interest after reading about these programs in the New York Times, after reading about the Wall Street Journal, after reading about the tweet. And so regardless of where the program originated, another government agency, a foreign agency, wherever, the CIA's burden here is to show what it asserts, the Glomar fact.
The CIA did agree to provide information relating directly to the tweet. Is that correct?
That's correct. We received
and have you received that information?
We received that information in the first Leopold case, and therefore in the second Leopold case, we did not request to have the same information provided again.
Okay.
But that is whether or not the CIA has documents reacting to the president's tweet is a different question from whether or not they have interest in a program that they allegedly conducted after that was revealed in the New York Times. They certainly have interest, even if they didn't have or know about the program before, they certainly have an interest in it once it was revealed to the public that they allegedly had such a program.
But wouldn't that, the interest after the tweet wouldn't that be covered by what the CIA agreed to provide? I mean, for example, suppose a CIA case officer emails another and saying, what the heck is the president talking about in that tweet? That would be covered, wouldn't it?
No, if
I mean, that would be disclosed.
The disclosure was only for documents that would not have revealed the existence or non-existence of the program. So if somebody said, what the heck is the president talking about, I think that would suggest that the program doesn't exist. If it was simply, how should we respond to the press, that was the kind of thing that was covered and released to us.
Okay.
The government argues, as far as how to interpret the tweet, that the terms massive, dangerous, and wasteful could be understood not as the president's words, but as those of the Washington Post. And certainly language is imprecise, and almost any statement can be endowed with ambiguity. But the core message of the president's tweet is unmistakable. It's a criticism of a news story. The criticism is that President Trump believed he made a good decision and the media lied to make him look bad. The tweet was not a book report describing the Washington Post's editorial view. It was not commending the Post on saying how Trump ended a massive, dangerous, and wasteful program. Those were his own words. And we know that this is the correct interpretation, not just from looking at the tweet itself, but also from looking at the context of the article and the follow-up comments to the Wall Street Journal. The government has argued that we conceded the point, but we included the text of the Wall Street Journal article in evidence in our cross motion for summary judgment. We referred to it there. We referred to it again in the reply brief. What we were getting at in the footnote was that the tweet was essentially a but-for causation. Had there not been a tweet, none of this ever would have happened, and we wouldn't have had the grounds. But as the court recognized in the ACLU versus CIA case, the cumulative total of evidence is relevant. And that was what we were getting at here. That's why we submitted that in the evidence.
With respect to the ACLU v. CIA case, the way that the Second Circuit read that case was that the totality of everything is what the court based its holding on. And that included statements by the CIA director, which demonstrated that the CIA had an intelligence interest in the drone program. So why isn't that the proper way to look at ACLU v. CIA?
Well, in some sense, the facts in ACLU versus CIA were more robust in terms of the number of statements that were being made. But this court certainly didn't suggest that what was in ACLU versus CIA was necessary to trigger the doctrine, as the district court noted. Any one of those statements may have been sufficient. There just happened to be a number of them. However, this case is, in some respects, an easier case than ACLU versus CIA because the FOIA requests here are much broader. And so even less would be revealed. And the match between the request and the information is even more precise here because the request literally duplicates verbatim the information in the tweet. The Second Circuit's decision was also, I think, arguably dicta in that respect because the focus of the court was on the CIA being the agency about whom the documents were asked. In other words, if it was, the request was focused specifically on covert CIA programs, which is not the case here. As the district court noted in our case, there's essentially a continuum with certain cases on one side, the ACLU, in the middle, and our case on the other extreme, where disclosure of the Glomar fact would reveal the least because of the breadth of the request. As far as whether it was CIA versus some other entity.
I guess I'm trying to understand that precisely, though, because if the request is broader, then there's potentially, and we say that they have to reveal the existence of documents, either by a Vaughan index or some other fashion to allow the court to determine whether exemptions 1 and 3 apply to them. Nonetheless, I mean, isn't that disclosure, if they have to disclose the existence of more documents, isn't that harmful to the intelligence interests of the agency?
Well, what they'd be disclosing here is something in the disjunctive, right? They have documents responsive to request part 2 or 3 or 5 or 6. So that tells the public less about what they have than if the CIA had specifically, than if the request had been, just part 5. But it's really up to the CIA to figure out exactly how they want to assert their Glomar response. In this case, they did it parts 1 through 3 and 5 through 9, but they could, under the district court's order, simply say, our new response is a much narrower Glomar in order to be tailored to protect the specific interests here. And so that's really a function of how the CIA has litigated the case.
It's undisputed that the Glomar response would have been perfectly valid, but for the official acknowledgement, right?
Right.
So, I mean, it's your burden to show official acknowledgement.
Right, and that's a burden of production. We pointed to that, but the agency always maintains the burden of persuasion, and that was clear from ACLU. You think it's the agency's burden to disprove official acknowledgement? I think the agency under FOIA always maintains the burden of persuasion.
To show the exemption, to show that the exemption applies, or to show that the Glomar assertion is valid.
Well, Your Honor,
I don't know if you have an otherwise valid response and you say, well, it's forfeited by an official acknowledgement. There a case that says it becomes their burden to disprove the acknowledgement?
Yeah, that was discussed in the ACLU case, and specifically what the court said, the burden on the plaintiff is the initial burden of production to point to, quote, to duplicate, pointing to information in the public domain that appears to duplicate the information that's requested. And then the court went on to quote some previous FOIA case law explaining that the burden of, the court didn't use the term burden of persuasion, but burden of proof is on the CIA. And I think that that's reasonable because the CIA is the one asserting a Glomar. And so all they're being asked to prove, they're not being asked to prove a negative or anything like that. They're being asked to prove that what they are saying is logical and plausible. And I think that that is a totally appropriate burden for them to bear.
All right. Any other questions, Judge Katsas, Judge Randolph?
No.
All right. Thank you, Mr. Light. Mr. Busa, you had some time left. We'll hear from you on rebuttal.
Thank you, Your Honor. I have 2 quick points to make. I'm also happy to take whatever questions the panel has. First, my friend on the other side made an argument here at oral argument that perhaps the tweet here should be taken as an official acknowledgement of some kind of U.S. government program. This goes back to questions a dialogue I was having with Judge Katsas during my time at the podium. But I just want to point out at page 7 of their brief, plaintiffs say the opposite. They say acknowledging the existence of responsive records would therefore not imply the payment payments were connected to the CIA or even the United States government. That's the basis on which this case has been litigated. And that's replicated at page 69 of the joint appendix, where the district court says that the payments could have come, quote, from somebody, end quote, not even necessarily the United States government, end quote. That's why the information at stake here is so important to protect. What we're talking about here is the CIA's intelligence interest or lack thereof, and also crucially, its intelligence gathering capabilities or lack thereof to learn about payments made by some unidentified source to Syrian rebels. Now, of course, we don't think the tweet actually acknowledges any payments to Syrian rebels for reasons we've gone into. But even on the second step, they have to show that the Glomar has been overcome with respect to the CIA's interests, and that has not happened here. Secondly, to get to the colloquy that was occurring between Judge Wilkins and Judge Katsas and my friend on the other side about the breadth of the request here, the fact that it asks for a lot of different documents, that does not diminish the damage that would come from disclosure. It compounds it for all the reasons we give in the last 2 pages of our reply brief. And Judge Katsas, you're right. My friend on the other side has conceded that Exemption 1 applies to the Glomar response here. That means it's not in dispute that disclosure would harm the national security. The only question is whether there's an official acknowledgement. That goes to the specific match test, which has not been satisfied here.
And what's your answer on the question of burden of persuasion with respect to official acknowledgement? Who bears that?
Your Honor, my understanding has always been that in the official acknowledgement context, the plaintiff has to point to an official acknowledgement and convince the court that it constitutes an official acknowledgement. I believe ACLU supports that.
All right, thank you. We have your arguments, and we'll take the matter under submission.
Thank you.
Case number 19-1256 et al., PCC Structurals, Inc., petitioner versus National Labor Relations Board. Mr. Peterson for the appellant, Mr. Lauro for the appellee.
Good morning, Mr. Peterson. We'll hear from you.
My apologies, Your Honor. I'm having just a momentary technical hiccup. Thank you. May it please the court. William Peterson on behalf of petitioner PCC Structurals, Inc. There are 2 main ways for this court to grant the petition for review. The first, and I think the easiest, is to recognize that the board's decision is insufficiently explained for this court to review and to remand for further explanation. Alternatively, if this court accepts the General Counsel's explanation for the board's decision, then both the community of interest and the craft unit majorities should be reversed because the board failed to apply or address its precedent in these areas. And with respect to the craft unit, PCC didn't receive notice that certification as a craft unit was at issue. Let me start with the board's need to give an explanation. As this court's well aware, as far back as Chenery, it's been clear that an administrative agency's decision can be affirmed only on the basis and for the reasoning set forth in the agency's decision itself. It's not enough for the agency to announce a conclusion. The agency has to explain its reasoning.
The regional director gave very elaborate reasoning, correct?
The regional director provided a significant analysis of the facts.
And which we could review. I mean, there'd be no doubt if the board had simply denied review and we were effectively reviewing the regional director's decision, there's enough there for us to look at.
Absolutely, Your Honor. To be clear, my argument here hinges entirely on the splintered board majorities. If two members of the board had said...
So we have a fully reasoned lower court, lower agency decision, and then we have the agency on review. As a formal matter, they deny review. They say there's no substantial question. Then they elaborate by saying that the regional director gave two different rationales, and two of them say we agree with one of the rationales, and a different two board members say we agree with the other. Why isn't all of that in context best understood as two different majorities have adopted each prong of the regional director's analysis?
Well, Your Honor, it's because of the form of the regional director's analysis. If you look at the regional director's decision here, the regional director did set out the two tests separately. The regional director listed, here's the community of interest test, here's the craft unit test. But when it came to application...
And found both of them met.
Possibly. In our view, we think it's read best as the regional director amalgamating the two, a craft unit that possesses a community of interest.
I understand that. And he goes through all of the factors once rather than twice. But he uses this formulation, a craft unit that shares a sufficient community of interest. Excuse me. That could easily be read as saying two different things. One is there's a craft unit, and the second is there's a unit that has a sufficient community of interest. And when you look at his conclusion at the end of that analysis, he actually has separate sentences saying the craft unit factors are met and the community of interest factors are met. Seems like those are alternative holdings.
Well, I think you could treat that as alternative holdings. But our concern here is, given the similarity between the tests, we think there's an increased need for explanation by the board. If we have two separate board majorities, neither majority says, we think the regional director got everything right. Each one says, we think the regional director got part of the analysis right, and is silent, but I think we infer from that that they are not adopting the rest of the regional director's analysis. And as we read the regional director's decision, it's virtually impossible to understand which portions of that were adopted by which of the two different board majorities. And we think in particular...
One majority adopted the two sentences saying the community of interest test is met because those factors weigh, 5-3 in favor. And the other majority adopted the immediately following sentence, which says the craft test is met because those factors weigh 3-0 or whatever.
And if we were looking at this and providing explanations on appeal, we think that's something the court could do. But I think this court can't speculate, can't guess as to which portions of the regional director's analysis the board adopted and why. This court needs to see that reasoning in the board's decision itself. It could be that the community of interest majority simply disagreed with the weighing of the craft unit factors. It could be that the community of interest majority disagreed perhaps factually with the consideration of the craft unit factors. It could be they thought the regional director erred by failing to apply North American aviation. We can't tell by looking at the board's decision what the basis was for each of the separate majorities' conclusions in a way that we could if two members of the board had said, we think the regional director got everything right here. But Your Honor, let me turn to the application of the tests themselves. And the first, of course, is the community of interest test. And we've talked about this in terms of a failure to apply Boeing. I think it's undisputed that Boeing was not a sea change in the law of community of interest. Boeing formally announces these 3 steps as 3 separate steps, but these steps are found in other decisions as well. In particular here, they were found in the PCC Structurals 1 decision. That's Joint Appendix page 1095, where PCC Structurals 1 directs the same 2 considerations that you see in step 2 and step 3 of the Boeing analysis. That step 2 is important, and we think it's meaningful because step 2 is a different perspective. Step 1 of the analysis looks at the community of interest among the petitioned for employees, here among the welders who would be included in the bargaining unit. Step 2 of the analysis shifts that perspective. It says, don't look at the included employees, look at the excluded employees and ask whether the excluded employees have meaningfully distinct interests in the context of collective bargaining that outweigh their similarities with the included employees. So when you look at the regional director's decision, at the board's decision here, you see the regional director focusing on the interests of the included employees. You don't see findings by the regional director about the interests of the excluded employees. And here, we think there are very strong arguments that the excluded employees do not have meaningfully distinct interests that outweigh their similarities with the welders. And it's important too, these are not simply interests in the abstract, but interests in the context of collective bargaining. So when you look at what the employees might want to bargain over, workplace discipline, that's shared both among the excluded employees and the included employees. Supervision is shared. Workplace rules are shared. Hours are shared. Excuse me. Wages, the employees are paid on the same wage scale, and there's an overlap among the wage scale for the welders and the wage scale for the other employees. To the extent that there are things that the excluded employees want to bargain over, those interests are shared equally with the included employees. So the failure to look...
Wasn't that argument specifically made as an objection to this bargaining unit definition? I mean, wasn't that really kind of, I guess, always a factor in this? Was that your client thought that the unit should be all of the employees?
Yes, Your Honor, that's always been our argument. We think there are certainly errors at concluding at step 1 that the included employees have meaningfully distinct interests. And in particular, PCC Structurals 1 emphasized the need to look at the practical realities of the workplace. And that, in our view, is what's most significant here. We have a highly integrated manufacturing process. The welders are working together with other employees who we think should be included to produce products. There's not a separate welding department. There's welders distributed among teams throughout all of the plants, and the welders are just one step in manufacturing a final product. And the third step of Boeing, also reflected in PCC Structurals 1, about any industry guidelines. You'll see we argued this to the regional director. It's Joint Appendix page 1145. We renewed it to the board, Joint Appendix page 1287. We argued that the board had given guidelines for manufacturing industries with highly integrated production processes. Now, what my friend's going to tell you is that's not the kind of industry guidelines that the board is talking about. But the problem is, right or wrong, that's an argument that needed to be decided by the regional director and the board in the first instance. And this court can't supply the reasoning on appeal that's absent from the board's and the regional director's decision. Let me turn now, unless the panel has questions, to the craft unit analysis. We think the easiest way of resolving the craft unit is to simply look at the notice given to PCC. The board's decision in PCC Structurals 1 reinstated the traditional community of interest test. It remanded to the regional director for application of the standard articulated herein. That's the traditional community of interest test. The regional director understood this and made this perfectly clear. I'd ask you to look at Joint Appendix page 1111. The regional director quotes the standard that the board directed that I use to analyze the appropriateness of the unit. He quoted that standard as the community of interest test. The union agreed with that as well in response to the show cause order, Joint Appendix page 1116, acknowledging that there is an 8-category test, that's the community of interest test, that will be applied in this case. The first argument that you see for certification as a craft unit was after the hearing in the union's supplemental brief. The union mentions the craft standards, but says that they complement the general community of interest inquiries. And in fact, that document, Joint Appendix page 1119, says that the board's decision remanded to the regional director, quote, to apply the community of interest test contained in United Operations. And closing, Joint Appendix page 1124, the union again acknowledged the community of interest test as the controlling analysis. So before the regional director, PCC had no notice that it needed to develop evidence or arguments about certification as a craft unit. And then finally, with respect to the merits of the craft unit inquiry, even apart from what we see as the due process violation, the concern there is the board's failure to address North American Aviation, the leading post-Mallinckrodt case regarding certification of welders as a craft unit. North American Aviation is, in our view, indistinguishable here. There was a highly integrated production process that the welders were just one part of. And in North American Aviation, the court concluded that any separate community of interest possessed by the welders was submerged into the more encompassing community of interest shared with the other employees. The facts relied on in Mallinckrodt were the same as the facts that we're relying on here. I'll also note, my friend might suggest that the welders in North American Aviation were less skilled than the welders in Hughes Aircraft, on which the regional director relied. Well, North American Aviation actually discussed Hughes Aircraft, and it distinguished Hughes Aircraft not expressly, not based on the skill of the welders, but based on the fact that Hughes Aircraft was applying the outdated American potash test. In fact, what the decision says there, for the purpose of the decision, we shall assume there is no material difference in craft functions. So North American Aviation was assuming that for craft purposes, the welders were equally skilled with the welders in Hughes Aircraft. Unless the panel has questions, I'll reserve the remainder of my time for rebuttal.
Thank you. We'll hear from Mr. Lauro on behalf of the board.
Thank you, Your Honors. Greg Lauro for the National Labor Relations Board, asking for the court to affirm the board's unit determination and order here. And before we get into it, just a couple quick points. I know the court understands that the issue before it is whether the welders unit is an appropriate unit, not the most appropriate unit. It's not material whether the larger unit preferred by my opponent is also an appropriate unit, and that their burden, and this is laid out in the briefs, is to show that the welders unit here is truly inappropriate. And of course, when it comes to factual findings, like whether this or that factor supported the unit, that's judged under the substantial evidence standard. Now, going to the issues that were raised this morning, I think that when you look at the two board majorities, it's easy to discern each majority's path. As was discussed this morning, you have a very detailed decision by the regional director. One majority says clearly it's adopting the regional director's community of interest analysis. That's clearly laid out in the regional director's decision. Another majority says it's adopting the craft unit analysis. That's clearly laid out in the regional director's decision. And there's nothing confusing or problematic about an agency laying out two alternative, independent, and sufficient grounds for its decision.
Well, it doesn't quite say we're adopting the analysis. They say we agree, this test is met or that test is met. It's a little bit, I mean, we need to make a little bit of a leap to say that they adopted not simply a bottom line, which wouldn't be enough, but the reasoning below.
I understand. I think it's clear from the context that what they're doing in reviewing the regional director's decision and saying we agree that this is an appropriate unit under community of interest is for the reasons stated by the regional director, and same with the craft unit analysis. I appreciate my opponent's arguments about how it could have been clearer. I just don't see, Your Honor, an unreviewable decision. I think it's clearly a reviewable decision, and I think it's well supported on the merits. For example, on the community of interest factor, the regional director factors either way. I think, like you said, it may go 5 to 3 or however you want to split up the 8 factors, but the regional director went through all of them and explained that yes, we have some factors like supervision and departmental structure and functional integration that could weigh against this particular unit. But we also have a lot of factors that make these welders distinct. They're a separate function. They're the only ones who do their function of welding on the product itself. They're the only ones who have the training and certification, which can take a significant amount of time to get and recertify. And because other employees don't have that training, they can't even temporarily do welding work. It's undisputed in this case that the non-welders that my opponent would include can't do the welding work. And I needn't belabor every factor. I know they're laid out in the decision you're reviewing, but on balance, looking at all the factors, it was reasonable for the regional director to find and for that board majority to adopt the finding that this is an appropriate unit under community of interest factors. And as to my opponent's point that the two tests were amalgamated improperly by the regional director, I don't think that's true. And it goes back to something Your Honor said this morning. First, the regional director properly laid out the two tests separately, acknowledged consistent with precedent that a craft analysis in a case like this incorporates some community of interest factors. And after that, where necessary, where the craft analysis required analysis of an additional factor, he did that very clearly. And he said in the topic sentence, turning to the craft analysis, I find, for example, that although there isn't a formal apprenticeship program, there's extensive training and qualification requirements prior to hire and after, which under precedent supports a craft finding. And he also did that on what's essentially an undisputed fact as to assignment of work on craft lines, that what I'll call the unit welders work is only assigned to the unit welders because only they are qualified and certified to do it. And so again, as to the craft analysis, you have a reasonable, well-supported finding that goes through all the factors and which a board majority adopted. Now, with that in mind, Your Honor, I'm happy to answer any other questions the court will have. I would just point out on due process that I think the record's clear that this isn't a case where a party was given no notice whatsoever that this related craft unit issue was at play. The parties indicated their knowledge of and actually litigated that issue, as the record shows, even prior to the remand. And I won't belabor the point again, because it's in the brief for your review, but the remand in PCC 1 didn't unring the bell of that prior notice and litigation, and did not scrub the case of the possibility of litigating the craft unit issue further. I think on balance, my opponent had notice and a fair opportunity to be heard. We explained in our brief that the cases they cited where notice was denied are what I call no notice at all cases. They're where towards the end of the hearing, a party was blindsided, as the court put it, by an issue they didn't see coming and they didn't have a fair chance to respond. I think when you look at all the facts here, due process was satisfied, notice and an opportunity to litigate was satisfied. And again, Your Honors, I'm happy to answer any questions you may have.
Does the board have any difficulty with the regional director's analysis to the extent it tended to merge the tests? And I'm sort of struck as far as there are no different legal consequences depending on whether we call this a craft unit or some other kind of unit. And the respective tests seem to have a huge degree of overlap. And the craft unit test just seems to use community of interest concepts as applied to workers who have some specialized skill. Mm-hmm. So, I mean, what are we fighting over here between the two tests?
No, what you say is true, and what we're fighting over may be a question for my opponent. They feel the tests were improperly amalgamated. What you just said, frankly, I think shows they were not. It's just precedent holds. There's a lot of overlap in the test in the non-construction industry. And as I noted before, the regional director did make that clear. Properly laid out both tests, indicated under precedent where the craft unit adopts community of interest analysis, and where there are some separate factors like assignment along jurisdictional lines. And then in his factor by factor analysis, made it crystal clear when he was separately addressing the craft factors. And in his conclusion, and you noted this, he said at one point, I find this is a craft unit suitable for bargaining and has sufficiently distinct interest under community of interest principles. He showed the two separate.
I guess the reason I'm asking you is I find that your opponent's due process argument is somewhat compelling in that, you know, the other test is coming up relatively late in the process, except to the extent that the tests strike me as very similar. And I just want to make sure you don't have any problem with that premise, if that's how I'm thinking about it.
If the tests do overlap, and under these facts, the choice of test may not be outcome determinative because it's a proper unit either way. If I may correct one statement or clarify one thing or to make sure I understood, Your Honor, I don't think the notice and litigation of the craft unit issue came late. I think it came early prior to the remand. And we have the sites in our brief where the union
it was mentioned in the first go round by the dissent, right?
Yes. But even before, if Your Honor means the dissent in PCC 1, but even before that, after the hearing, the first hearing, before we get to PCC 1, the parties are litigating the craft issue. And my opponent does split hairs a little bit here. There's a quote in the union's brief at that time that the unit here is akin to a craft unit because of their distinct licensing and experience and certification requirements. And the argument is akin to craft isn't the same as arguing craft. I don't know about that. I think it shows notice of the issue. And my opponent responded back then, before PCC 1, by arguing the same case, North American Aviation, that they're arguing now for craft purposes. So I think the bell of notice was rung back then very early in the process. And I just wanted to be fair to the record on that, Your Honor. Thank you for raising that.
All right, thank you. Any further questions, Judge Katsas or Judge Randolph?
No.
All right, thank you, Your Honors. If I may just say in conclusion, I do think that viewing the record as a whole and the regional director's detailed analysis and the board's adoption of it, substantial evidence supports the finding that this was an appropriate unit under both or either test, and thus it should be affirmed. There's no need for a remand. So thank you, Your Honors.
Thank you. Mr. Peterson, we'll give you 2 minutes on rebuttal.
Thank you, Your Honor. Let me start with the notice question. We believe there is a world of difference between arguing that they are a community of interest that is akin to a craft unit versus actually seeking certification of the unit as a craft unit. When this court looks at the party's briefing prior to PCC Structurals 1, you will not see the unit seeking certification as a craft unit. You will not see PCC responding by arguing the craft unit factors.
To walk me through why the different tests, the selection of a test makes such a big difference, because I mean, just sketching this out, there are 5 factors for craft unit. Then there's a general statement that in non-construction craft unit cases, you look to all the community of interest factors anyway. And when you look at the 5 craft unit factors, as far as I can tell, 3 of them have complete overlap with the 8 other factors, and 1 has only a slight variation, training versus training in an apprenticeship program. And the only one that seems somewhat different is whether work is assigned on jurisdictional lines or not, which is not hugely different from the question of what work they're doing. But in any event, I mean, you see where I'm going. It's just, as a non-expert, it seems to me like this is a lot of fighting about relatively minor verbal formulations of the same basic concept.
Well, Your Honor, I think you're right. And I will tell you that is why the board's decision is so strange in PCC Structurals 2 is because
if I'm right, doesn't that blow up your due process argument?
No, Your Honor, because there are separate factors there. They would need to be argued separately. We simply didn't have a chance to make these arguments before the board. But let me point you to the board.
If we're shifting from test A to Z, that's a bigger problem for the board than if we're shifting from test A to A prime. And this feels to me like we're shifting from A to A prime.
Well, I think that's right. I will tell you what we know absolutely from the board's decision in PCC Structurals 2 is that the majority of the board viewed the tests separately and believed that the difference in the tests mattered. It might be one thing if two members of the board had said, we agree with it. Again, I don't have a great explanation for why the board majorities reach different decisions. I don't think my friend has a great explanation. And that's why the board's failure to explain what it sees as the difference between these tests is so significant.
But then they seem to say in PCC 3 that there's no big difference.
Well, we weren't arguing. I think the board, I'm not going to say misunderstood our argument, but we weren't arguing that there is inconsistency between the outcomes. We weren't saying there's something impossible about two judges finding it satisfies craft unit, two finding it satisfies community of interest. But what we were saying is we don't know why. And that, in my mind, is the heart of the problem. The board has not always been perfectly clear about the relationship of these tests. One could certainly imagine a world in which the board was always looking at a community of interest and simply looking at these craft factors as additions. I think that would be perfectly sensible and rational. When you look at the board's precedent, you just won't see that. And that's why here, we think if the board's going to have two majorities, one says yes to craft and one says yes to community, it's really necessary to give us the explanation of why they mattered. And Your Honor, if I can make just one more point before sitting down, I'd like to point out what you didn't hear from my friend about the application of the community of interest test. What he didn't do was point you to a finding about what Bowen calls step 2, an examination of the interests of the excluded employees. And what he didn't do was point you to a finding or analysis by the regional director of the board of Bowen step 3, the industry guidelines.
Can I, just to go back to Judge Katsas's questioning, is there a difference in the rights of the union or the employer if the unit is certified as a craft unit instead of as a unit under the community of interest test?
No, Your Honor, there's no difference.
Okay. All right. Anything else, Judge Katsas, Judge Randolph?
No.
All right. Thank you. We have your argument. We'll take the matter under advisement.
Thank you.
This honorable court is now adjourned until Friday, November 13th at 9:30 a.m.